Well, yeah, you mentioned some cases that seem to be prevalent, and then those are the ones that everybody latches on. So let's look at the cases here. There's someone that tweeted something about whether we need special courses for corruption.
Special courts.
Special courts or courses to deal with corruption issues. But let's go to the question of delay in justice. Why do we have cases delayed so much? Is it reforms that will take care of that? Is it a question of character or infrastructure?
The answer to this, you look at the structural aspect, and then you look at the human aspect. Structural, statutory, in the sense that the rules of court provide certain guidelines which you must follow. For example, if you have an originating process, you serve the other party. Sometimes it could take 6 months to do what we call proper service in law. That delays, because if you have not even entered the room, how do you have lunch inside the dining? You're finding it difficult to open the door because the key is not playing ball. You have to try and try until you open the door before you enter to have the lunch. So your lunch could be delayed on account of that delay at the door. So now when you finally open the door and kickstart the judicial process by properly serving the originating processes, there are rules as to when the defendant or the defense will need to also reply by filing its own defense. And all things done, cases are now, maybe the pleadings are closed, and then trial begins. A lot of things now come in. If you see that you don't have a case, there are some lawyers, when they see that they don't have a case, having advised their client to go ahead, maybe because of the money. But why I frown at that is that I tell my clients, I don't sell crayfish, I don't sell pepper, I don't sell Coca-Cola, or any of the soft drinks. It's what I say, based on my knowledge, that you pay me for. So if I say, please don't go to court on this thing, you have to pay my bills. Because I have saved you 10 years of perhaps adverse litigation process. Then our system is a win-lose, not a win-win. So you have permanent enemy in that person that you are proceeding against. But if you have a win-win, let's talk it over and find a way to save everybody's face. Tomorrow is always larger than today. You think I'm your enemy today? Tomorrow my daughter can marry your son, or vice versa, or any of the relation, and you are the uncle presiding. What would be the face if we had not settled today? I don't know whether you get the point. So there are factors of lawyers who also deliberately, especially in the criminal process, even in civil litigations, land cases can last for 13 years, 20 years, even sometimes at the lower court. But somebody is in occupation. The person in possession that is wrongly so will be harvested, doing all sorts of things that possessory right, granted. So there are human aspects that are deliberate. There are the ones that are statutory. The ones that are statutory are the ones that we are now talking about, reforms. Because if the statutory ones are reformed appropriately, it can control the human, misconduct, so to speak, because the water will take the shape of the container.
Okay, let's bring it to Chief Noruka. Chief Noruka, if the statutory reforms are done, they can take care of the human side of it. Will that work in our situation? Let me give you a case in point. A case against a former governor of your state, after 9 years, was just taken back to the court. After 9 years. Can we get past this point of view? Because there are still other cases that are still languishing in litigation at different courts that have not been seen through. Cases that should have been done and dealt with.
Yes, let me start by pointing out that the answer to the question you pose is absolutely yes. we can overcome these systemic delays in the system, but then it requires the proper attitude and proper character in the judex, in the judge sitting. My concern is that it is not often understood that every practicing lawyer and advocate in a court of law loves technicalities, especially when it favors him. But the position of the judge is to bear down on technicality and ensure that it does not cause undue delay in the administration of justice. But that is not the case. You find that the judges will virtually take you on a sing-song about the evils of technicalities, but they will be the ones very, very ready to latch onto it in order to achieve an adjournment of a case so that they can rest. So I think at the end of the day, it is still a question of judicial indolence or laziness. Only a judge can stop a lawyer from truncating justice with technicalities. Unless the judge is willing to use that weapon which he has to ensure that proceedings in the court are allowed to go on without unnecessary bickering over technical breach of rules, then we will always have our delays. There is this, you've just given an example. You wouldn't probably know that there was a case that traveled all the way from the High Court to the Supreme Court, a long case, as Nnaji pointed out. After that journey of 30 years, it came back to start a second journey from the High Court because it was sent down for a trial. Now, it made its second journey to the Supreme Court again. And do you know what? The issue being canvassed was that the entire trial was null and void because the defendant could not see the writ of summons.
Aruka, just hold your thoughts. We'll take a moment. When we'll come back, you can finish up on this tangent you're going on. We'll be back shortly. Don't go away.